Okay, guys, let's get into Chapter 5, Labor and Employment Laws and Regulations. Once again, if you guys want to be added to the WhatsApp group chat, the number is down below and in the pinned comments. Just message me and you'll be added to the group. So let's get into Chapter 5. I'm pretty sure this is the longest chapter in the entire book. The questions that I did have were math questions. I'll get into it when we get to there. It was pretty simple. What I had on the test, I just went to this part of the book. You just follow the steps and I was able to get the answer. I have highlighted here Labor Management Relations Act, Fair Labor Standards Act, exemptions, overtime pay requirements, record keeping, child labor regulation number 3. Unemployment benefits, penalties, sanctions, special issues related to the construction industry. And this one, I had questions from here, so make sure to have this highlighted, starred, everything. Immigration Reform and Control Act of 1986, record keeping, the Fair Labor Standard Act, Florida Child Labor Law, Florida Reemployment Assistance Program Law, Employer Guide to Reemployment Tax, Employer Guide to Reemployment Assistance Benefits. All right, so let's get right into it. These ones are the labor and employment laws and regulations. I just have these highlighted. Maybe just read through all of these and just highlight the name of each one. Here's another one. The age discrimination in employment, treating employees 40 years and older differently because of their age unless the employer can legally justify its actions. National Labor Relations Board, NLRB. So if they ask you what NLRB is, it's a National Labor Relation Board. Duty to bargain. Employers and unions have mutual obligations to bargain in good faith over wages, hours, and other terms and conditions of employment. Neither party is required to make particular proposals or concessions. The NLRB, acting through a member of regional offices, prosecutes unfair labor practices charges and conducts representation elections. If they ask you who is in the enforcement of unfair labor practice, it is the NLRB. Unfair labor practice charges and unfair labor practice charges ULP must be received by the regional office where the unfair labor practice is alleged to have occurred within 6 months of the alleged violation. Representation elections. In the construction industry, an employer can sign a bargaining agreement with the union without employees' majority support for the union. Coverage. Exception to coverage include employees who work in federal enclaves, such as military bases, and employees working for airline on railroads. Requirement prohibition. Florida is a right-to-work state. Specifically, the Florida Construction, in conjunction with the Florida statutes, prohibits collective bargaining agreements that require union membership as a condition of employment. Union shop agreements. An agreement whereby an employee is forced to join a union within 30 days of hire of the effective date of the agreement, whichever occurs last under penalty of discharge. Agency shop, maintenance of membership. So right here, the FLSA is federal statute which prescribes minimum wage of $7.25 per hour for non-overtime work. Overtime compensation at time and 1/2 the employee's regular rate. Test for exemption. Employees compensated on a salary of fee basis at a rate of not less than $13 per week. I don't have anything here. Nothing here. Okay, so this is important right here, this part right here. So let's go through this first. Each work week stands alone. Single work week as its standard and does not permit the averaging of hours over 2 or more weeks. Determining work week. Regular rate of pay. This is important right here. The regular rate of pay may be more than the federal statute minimum $7.25, but cannot be less. Right here, this footnote is important. Highlight it. Footnote 1, in Florida, as of January 1st, 2020, the rate is $8.65 per hour and will increase to $10 per hour on September 30th, 2027. The rate will increase every September 30th for the next 5 years until it reaches $15 per hour. Hourly rate employees. So right here, once again, this is important. You got to know how to do this math. So hourly rate employees, and then they're showing you how to get the overtime for it right here. So he makes $7.25. It's times 40 is $2.90. So his overtime rate is $10.88 times 6 hours, because he worked 6 hours of overtime, is $65.28. And then the $2.90, which is from here for his regular rate, plus the $65.28 for his 6 hours of overtime, he got $355.28 total. So when I had a question about overtime rate, I just went here and looked at their math and followed the same steps to get the same exact answer on the test. Another method that can be used, this is just another method that they're showing. Hourly rate and bonus. So here it's $7.25 per hour times $333.50. $333.50 calculated base plus $9.20 bonus is $342.70. So now you got how much it is with the bonus. So then you have to divide for the 46 hours he worked, which his base pay with the bonus is $7.45. So then you would do $7.45 times 46 hours is $342.70. And then you would do that. The overtime rate times 6 is 223.38, because he did overtime as well. So yeah, right here, where does it say he did overtime? Oh, it's coming from this question. So he did overtime, it's 22.38. So it's right here, 34.270 with the bonus, with the $22.38 for the overtime rate. So he got $365.08. So when you give someone a bonus, it's just not that like right here, it's just not a $9.20 bonus. It's actually going towards their hourly rate, and then it will be multiplied. These are important. Make sure you understand these two. Employees paid on salary. I didn't have any questions from this, but make sure to know it. I didn't have anything from here either. I didn't have anything from here. Bonuses. A bonus need not be included in the regular rate if the employer retains discretion. Both. 1, that a bonus will be paid, and 2, that the amount is not determined until the end or near the end of the bonus period. Gifts, Christmas, and special occasion bonus. It may be excluded from the regular rate. So these ones, this is different from the hourly rate and bonus. So make sure to understand that. Pay for foregoing holidays and vacations. On-call pay, I have highlighted. Daytime pay may not be waived. Overtime must be paid after 40 hours a week. May not be waived by agreement between the employer and employees. I had this on the test. Record keeping. Super, 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 super important. Employees are required by regulation to keep so-called hard records, such as payroll, employment, contracts, or agreements, and sales and purchase record for 3 years. All other required records, so-called soft records, must be kept for 2 years. Among other records, these would include time cards or time sheets. The following information must be recorded for each covered employee. Here you go, all that. Construction industry, child labor restrictions, type of work. Children aged 15 and under may not be employed in a number of occupations, including construction. Child aged 16 and 17 may work in construction-related operations, but may not be involved in certain particular hazardous occupations at a construction site. This is the occupations that they cannot do. Labor laws, number 3, no minor under 18 years of age is permitted to work in any of the following occupations. Hours. Under the FLSA, minors who are 14 and 15 may not work outside school hours in various non-manufacturing, non-mining, non-hazardous jobs under the following conditions. No more than 3 hours on a school day and 18 hours in a school week. I had a question like this. They were asking, like, how many hours can a 14 and 15-year-old work on a school day? And it was no more than 3 hours on a school day and 18 hours in a school week. No more than 8 hours on a non-school day and 40 hours in a non-school week. No earlier than 7 a.m. and no later than 7 p.m. except from June through Labor Day, when evening hours are extended to 9 p.m. Just read through all of these items. These are pretty important. I had a question on a test about this. Enforcement penalties. Here's all the penalties. Make sure to highlight those. The Davis-Bacon related acts. Employers with contracts valued in excess of $2,000. Just read through that. Penalties, sanctions, alleged underpayment of wages. Debarment from government contracts for up to 3 years may also be imposed. The Civil Rights Act of 1964. All right. Covers all employers that employ 15 or more employees in each of 20 or more calendar weeks in the current or preceding year. Labor unions and employment agencies. Enforcement must be filed within 300 days of an event triggering prohibited discrimination. Right here. This is, once again, what I was saying in other videos, is you're pretty much taking a law exam. You're not really taking an exam on construction. And they just want to make sure you know the law. So make sure to highlight these. The coverage. The FCRA, 15 or more employees for each workday in each of 20 or more calendar weeks in the current or preceding calendar year. Alcoholism is a protected handicap. All right. I didn't have anything from here, but just make sure to highlight and know where this stuff is. I'm just going to flip through these and you can pause and highlight what I have. Once again, if I don't have something highlighted, does not mean it's not important. Okay, so enforcement. So this is enforcement for Family and Medical Leave Act of 1993. So the Secretary of Labor may investigate compliance and bring suits, or an employee may bring suit in state or federal court. Suits may not be brought late than 2 years after the violation unless the violation was willful, in which case the period is extended to 3 years. Federal Rehabilitation Act of 1973. An aggrieved party must file a complaint of disability discrimination with the OFCCP within 300 days of an alleged discrimination act. Okay, American with Disability Act. This one highlight employers with 15 or more employees for each workday in each of 20 or more calendar weeks in the current or preceding calendar year. So this is saying that you have to get coverage if you have 15 or more employees. A physical or a mental impairment, the substantially limits one or more of the major life activities of such an individual. That's defining what a disability is. Reasonable accommodation. An employee is not required to offer all possible reasonable and accommodations or even the most reasonable accommodations. Pre-employment medical examinations are prohibited. Make sure to have that. An employer can require post-offer but be pre-starting work medical examinations and condition of the offer on the results of the examination in order to do so. During employment, employee medical examinations are generally prohibited. Current users of illegal drugs are excluded from the protection of the ADA. AIDS, right here. You can just highlight these that I have highlighted. I don't remember any questions from these, but I did have that highlighted. The Employment and Training of Veterans Act. The act applies to government contracts and subcontractors with contracts worth $100,000 or more. 180 days of the alleged violation. Boom, boom, boom. Okay, this one's a good one. This might be on your test. I don't remember having it, but I remember people saying they had it. The Florida Clean Indoor Air Act. Penalties, sanctions. An individual who violates the prohibitions against smoking is subject to a non-criminal fine of up to $100 for his first offense and up to $500 for each subsequent offense. Employee Polygraph Protection Act of 1988. I have those. Unemployment benefits. Make sure to read through this and highlight what I have. This one is a pretty important section, the unemployment benefits. Right there. Just read through that. Okay. So, Immigration Reform and Control Act of 1986. So, if you have a question that is talking about Form I-9, the Form I-9 is the Immigration Reform and Control Act of 1986. So, if you get an I-9 question, come here, and most likely the answer is here. Employment verification. Under IRCA, an employer must verify the identity of all new employees as well as the individual eligibility to work in the United States. In this regard, the employer must also complete an employment eligibility verification form I-9. The I-9 must be completed by the employer and the employees within 3 business days from the day the employer begins work. Right here is where I had the question. Once again, you get I-9 on the test. You're coming right here to the Immigration Reform and Control Act of 1986. That's why I had this highlighted here. Where is it? What page? Right. Boom. Immigration right here. I-9. And if you go, let's go into the index and see if we can find I-9 in here under forms. No, it's not here. So let's look at immigration. Nope, it's not here. So the only way to get to it is if you actually know it. So let's see if it's under labor. Labor laws. No, it's not under there. So this is one of them that you have to know where it is and go exactly to where it is. Okay, so right here, what I was saying, I had this on my test, 100% guaranteed. The I-9 must be kept for all current employees throughout their employment. For terminated employees, the I-9 must be retained by the employer for 3 years after the date of hire or 1 year after the date that the individual no longer works for the employer, whichever is the later date. So I had a question that was like, this person was hired this date and they left this date. How long do you have to keep the I-9 for? And it was just 3 years, luckily. And then the penalties, these, I don't remember seeing any of these. Florida law, don't remember any of that. And through here, I just have child labor. I don't think I have a lot of things highlighted, but let's find out. Let's go through it together. Yep, doesn't look like I have anything. Once again, if you guys want to be added to the WhatsApp group, the number's down below. Just text it and you'll be added into the group. It's other people taking the test, so you can find a study buddy and get this thing passed. Okay. All right, I have this one, exempt and non-exempt work, 541.702. Oh. Yeah, I don't remember going through this on the test. I didn't even study any of this, to be honest. I don't think it's nothing you have to worry about. But once again, they can ask you anything from the test. But I wouldn't spend a lot of my time studying any of this stuff. Once again, it's more of like, these are the main laws, and they kind of recap it in the beginning of the chapter, so you don't have to read through all of this, but they put that in there just to make sure you have it. Yeah, I don't have anything in here. Keep going. Let's see if something pops up. I don't think so. Comment down below what you guys are having the hardest time with, and I can probably make a video and go over it. So now we're at what employers need to know about reemployment tax. I actually went to this when I was on the test. It's pretty good. Who pays for reemployment assistance? You, the employer, pay for reemployment assistance through a tax managed by the Florida Department of Revenue. So they might ask you on the test, it will say like, Michael made $5,000, and how much does Michael need to pay in reemployment assistance? And it will say like $1,000, $200, $300, or $0. And it's a trick question because the employer pay for the reemployment assistance. So the answer would be $0. So that's something that might pop up on the test. And boom, boom, boom. Employment not covered. This is cool to know. Highlight that. Right here. Oh, this is a good one that I had. It was asking me what in a specific form was, and I could not figure out what it was. And it was I think it was an RT 5 or RT 6, and it was asking like when you had to file it. And I was like, man, where is this? I couldn't find it. And I finally flipped through and I found it on one of these pages. Let me see if I can find it. You must file your employer's RT6, including any correction, and pay the tax electronically if you're an employer who employed 10 or more employees in any quarter during the preceding state fiscal year. So you have until July 1st and June 30th to pay it. The tax rate now for new employers is 2.7%. Businesses proceedings. Form RT6NF allows you to report out-of-state employment wages paid to employees who worked in another state and transferred to Florida. I think that was another question on my test on what is a form RT6NF. Okay, so this is important to go through, like right here. This is the like know these type of forms and when they have to be submitted, because once again they had it on my test. The maximum tax rate allowed by law is 5.4%. Like they could ask this, when is the RT20 mailed to employers? And then right here, mailed to each employer in December. That's a question they could ask you. Employer's Guide to, did I miss a page? No. Employer's Guide to Reemployment Tax. Right here. Employer or an independent contractor employment quarterly report, RT6, excuse me. Right here. This is a really good like cheat sheet. So make sure to have these highlighted and actually read through this and know this stuff. An employing unit is the person, limited liability company, partnership, corporation, or other legal entity for whom service is performed. That's an important, the employing unit. Employment not covered. Once again, highlight these, pause the video, and you can highlight them. Penalty for failure to file electronically. Correcting your report. New hiring or hires within 20 days of employment hire day. Tax rate. 5.4%, 2.7%. You probably already know that, have that memorized. Excess wage. So these are the glossaries. Once again, another cheat sheet. If you don't know a word that they're talking about, you can just come here and go to the glossary and find it. It's a short glossary, but it is here. Employer Guide to Reemployment Assistance Benefits. I have this. Monetary qualifications, and I have these highlighted. I have that. An appeal must be filed within 20 days from mailing date of the termination. And then the tax rate right here. Initial tax rate 2.7%, standard tax rate 5.4%, and maximum tax rate 5.4%. So there you go. We finished chapter 5. Make sure you guys like and comment down below, and I'll see you guys in chapter 6 next, workers' compensation.